Good morning to you. Today we will see the amendment to the CCA CCA Rules 1965. A recent amendment in October 2022 regarding Rule 10 of CCA CCA Rules 1965. This was notified on 19th October 22 and obviously effective from that date only. In nutshell, the amendment has fixed a time limit for the period of suspension. How much a person can be placed under suspension, how long, what is the duration, the maximum period of suspension. That is what the amendment seeks to provide. I will explain the amendment very simple way. You will be able to understand, I'm sure. First of all, remember, the amendment has been made to the amendment has been made to the CCA Rules 1965. If there is a rule, there should be an act. Is there any act which provide the CCA CCA rules? No. Because it has been derived, the powers have been derived directly from Article 309. You can always see, in any amendment, they will say, by deriving powers from Article 309. What 309 says? The appropriate legislature can make law to regulate the recruitment conditions of the government servant. And if so long there is no law, the president or governor, as the case may be, is competent to provide rules governing the conditions of service and appointment of the government servants placed at the disposal of such union or state. So first thing you should remember, this is as a deriving powers from Article 309. There is no separate act. And if there is no separate act, remember, the subordinate legislation does not come into the picture. Because there is no committee on subordinate legislation which has examined the rules. Normally, if there is an act, if there is a corresponding rule, then both these rules and acts should be examined by the Parliamentary Committee on Subordinate Legislation. In this case, it does not arise because the powers have been derived directly from the Constitution. Remember, from MCQ point of view. Now, coming to the amendment, remember, there are 3 statutory circumstances for placing a government servant under suspension. And there are 4 statutory circumstances for placing a government servant under deemed suspension. First, before entering into the amendment, you should know these 7, 3 plus 4. What are the statutory circumstances? Number 1, where a disciplinary proceeding is contemplated or pending. Number 1. Number 2, where the activities of the government servant are prejudicial to the interest of security of the state. Number 2. Number 3, where a case against the government servant in respect of any criminal offence is under investigation, inquiry or trial. These are all the 3 statutory circumstances. There are many administrative instructions. That has not been given the statutory basis. This is just statutory, as good as a law. Now, there are 4 circumstances of deemed suspension. 3 circumstances of suspension statutory. And there are 4 circumstances of deemed suspension. Number 1, detention in custody on a criminal charge or otherwise beyond 48 hours. Remember, beyond 48 hours, the deemed suspension will be effective from the date of detention. This is number 1. Number 2 is conviction and sentencing to an imprisonment of more than 48 hours. Detention also more than 48 hours. Conviction also, conviction and sentencing. Both are different. You should know the difference between conviction and sentencing. Conviction is he is guilty. Sentencing is for the guilty, for the guilt. What is the punishment? That is sentencing. So conviction and sentencing more than 48 hours. In that case, the deemed suspension will be effective from the date of conviction, provided the government servant has not been dismissed or removed on the ground of his conduct which has led to his conviction on a criminal charge by invoking Rule 19 of CCA Rules 1965. Now, third circumstances of deemed suspension is where a penalty of dismissal, removal, or compulsory retirement imposed on an official who is under suspension is set aside by the appellate authority or by the reviewing authority, and the case has been remitted for further inquiry, then the order of suspension is deemed to continue from the original order of from the date of original order of dismissal, removal, or compulsory retirement till the further orders. Till further orders, it will be deemed suspension. Remember, this is as a result of review or appeal. Remember. The fourth one is the government servant where a penalty of dismissal, removal, or compulsory retirement imposed on a government servant is set aside by the court. Remember, first is appellate authority or reviewing authority. Fourth is what is third and fourth. Fourth is if it is set aside by the court of law and the disciplinary authority having considered the circumstances under which such reinstatement is ordered by the court, the disciplinary authority is free to remit the case for further inquiry. Suppose if it is on technical ground, purely they have not followed the proper procedure, there is a violation of Article 311. So they can conduct a de novo inquiry, and so during the period of from the date of original order of dismissal, removal, or compulsory retirement till the conclusion of the proceedings, he will be deemed to be under suspension. So remember, there are 3 statutory circumstances of suspension, 4 statutory circumstances of deemed suspension. Remember. Now come back to the amendment. What is they have fixed time limit for this? Very simple. They have kept the time limit for all these things. Do you think there is no time limit now? Yes, there are time limits. Administrative instructions have provided. But nevertheless, they have been given statutory basis by the government. Now, you know the basic thing. Any suspension order is valid only for 90 days. Okay. Now, beyond 90 days, a review committee constituted for the purpose should examine the desirability of prolonging the suspension and recommend. Remember, the review committee will only recommend to the competent authority accordingly on the basis of the recommendation. It is not mandatory for the reviewing for the competent authority to agree to the recommendation. Remember, there may be a question: who reviews the suspension? Immediately we say review committee. No, the review is made by the authority who is competent to order suspension. So the review committee will recommend. On the basis of the recommendation, the competent authority will review the order of suspension and accordingly modify or revoke the order of suspension. So remember, this is the basic number 1. Number 2, this review is not necessary in the case of deemed suspension, because it is not in our hand. Very simple. It does not require any elaboration. It is not in our human. It is in the custody of the police. So we cannot have any review on that. It is not because of the department. So no review is necessary in the case of deemed suspension where the government servant has been detained in custody. Then does it mean he will be allowed to be continued in suspension? No. The 90 days limit will be counted from the date of release of the government servant after the detention. Suppose let us say after detention also he has not intimated the appointing authority, then either from the date of release of the detainee from the custody or from the date in which the fact of release was communicated to the appointing authority. Remember, appointing authority, whichever is later than 90 days. As you already know, any extension of suspension can be at a time cannot be more than 180 days. Remember, very important. 108, more than 100 at a time. 90 days, okay. Then 180 days, the review committee can recommend up to a maximum of 180 days at a time. Okay. Now you come. Second is, in the case of, first case I told you where a government servant is suspended on the ground of what is known as disciplinary proceeding pending or contemplated. In this case, remember, the maximum period of suspension is 270 days. And before 270 days, the charge sheet should be issued. That is the intention. So if no charge sheet is issued, what is the maximum period of suspension? 270 days. How do you come to this 270? What is the sanctity of 270? Very simple. 90 plus 180. So they can give only one extension. 90 plus 180, 270 days. Okay, in the case on the ground of second is the activities of the governments are prejudicial to the interest of security of state. In this case, remember, it is 2 years. It is 2 years. That is, if no charge sheet is issued, he cannot be allowed to be under suspension for more than 2 years. That means charge sheet is technically not a limit for the suspension. It is a limitation for issue of charge sheet. Remember. The third is, if the detention in custody, the maximum period of suspension will be from the 2 years. Suppose the government servant has been under custody and he has been under custody for 2 years, 3 years, etc., and he has been released. So in such cases, the maximum period of suspension is, if no charge sheet is issued, it is 2 years from the date of detention, or from the date on which the fact of release was intimated to the appointing authority, whichever is later. So this is the amendment made. If you read the amendment, it is as confusing as normally any amendment to the rule. It is all who made it? Only you. You are a potential, so you can make it. Tomorrow you will be in law ministry. Tomorrow you will be in DOPT. So tomorrow you will be in home ministry. So you only make the rules. Maybe the cosmetic changes may be made with a legal advisor, assistant legal advisor, etc. That does not matter. The crux you should understand. With this, we end the class. Thank you.